good afternoon. Looks like we've got the Repco family and a couple other people out there, but we're still going to try and make this happen. Don't tell our luncheon speaker, but I was counting how many Rolexes are on this panel, and it's more than one. Let me introduce our august panel. To my right, Katie Coleman is a partner at Hughes Hubbard & Reed in New York. She's been representing companies, buyers, and financial institutions, both in and out of court, for over 25 years. Next, Steve Shimshak, partner at Paul Weiss. And Steve has a diverse practice with a particular emphasis on complex bankruptcy litigation, both U.S. and foreign insolvency proceedings, restructurings, workouts on both the debtor-creditor side, court-appointed liquidators, trustees, asset purchasers, and private equity investors. By the way, by the time I'm through with the introduction, I'm going to be saying in conclusion. Next, we have Larry Laddig, who's the president, the capo de tutti capo of Messero Financial Consulting. He provides financial advisory services to post-confirmation trusts, creditors committees, lenders, companies and creditors, and buyers and sellers in M&A transactions, and parties in financing and financial transactions. But I just know him as somebody who's working with me on the hostess matter. Then we have Joe Garrity. He's a senior managing director at Conway McKenzie. By the way, I like adding the senior. I think I'm going to add that to my title. That really sounds
that's good. It worked.
Good.
It worked.
It's good. He's with Conway McKenzie, specializing in turnaround and crisis management, insolvency and bankruptcy matters, and M&A. He has directed, managed, and led the restructuring and turnaround of companies with sales ranging from the lower middle market to over $800 million in revenues. His industry specialization is automotive, aerospace, paper, and healthcare. Last and certainly not least, Bill Repco, the man who really needs no introduction, but I'll give one anyway. Senior advisor and co-founder of the Restructuring and Debt Advisory Group at Evercore Partners. Is all of that on your card? I would like to see the card. Bill spent 32 years at J.P. Morgan, where he founded and was chairman of the Restructuring Group, and was a legendary practice that he created and led for distressed credits before co-founding the Evercore Partners Restructuring Group. Okay, I'm exhausted. I need a nap after that.
I told you not to stand up.
All right, our first topic is playbook versus particulars. A lot of, if not all, restructurings seem to be following a playbook that may or may not work anymore. Do too many deal makers follow the traditional playbook? Katie Coleman's going to define what that is. And does that emphasize process over substance? Are there potentially better approaches? Katie, you want to kick it off?
Okay, well, I think that we agreed, since none of us could decide what the playbook really was, other than a very successful movie, we thought that each of us would kind of define for ourselves what the playbook is. And if we're talking about kind of the process of how you organize a big deal with a lot of constituents, obviously you need some kind of organizational template. Otherwise, it will descend into chaos. And I think what Peter's really talking about is a kind of a rote way of looking at transactions, and are we kind of as an industry in danger of falling into that? And I'm talking about particularly the more middle market deals. I mean, obviously there is no playbook for a GM, and if there was, you'd have to throw it out, as clearly happened there. There may not be a playbook for a lot of the larger cases, but a lot of us deal with the middle market, however you define that cases. And the danger that I see there, you won't be surprised to hear that I'm saying this mostly as a company side lawyer, but the danger I see there is the case is kind of predetermined by the senior secured lender, or by the bondholders who are coming in and saying we're gonna kind of hopscotch our position and become the dip lender. Because what's happening in a lot of these cases where there isn't huge access to liquidity, it's not a big company that has a lot of options in terms of financing. You got one option in terms of financing, and that option is telling you, here's what your dip is going to say, here's what your dip budget is. You'll notice that the dip budget only extends to letting you sell the company in 60 to 90 days, and that's what's going to happen here. And oh, by the way, you have to send us, as the Lenders Council, a copy of every pleading you're going to file, and we have to be happy with it before we're going to allow you to file it. Otherwise, we'll declare your dip in default. And your plan has to be satisfactory to us. Otherwise, again, you won't have any financing. And that's enormously constraining, obviously, for companies.
Is that really the golden rule? You has the gold rules?
It is. It absolutely is. And I think that companies in the past have been able to look to creditors committees and look to judges to some extent to say, hey, help us out here. And there's really a limit as to what the judge can do, because he or she cannot force the lender to lend, and then you've got no financing. Again, I'm not talking about the mega cases where there's an opportunity for somebody else to come in and do the financing, but I think that's a real danger, and I'd be interested in the other.
I think it's been an interesting evolution, and I agree with a great deal of what you've said. With the degree of sophistication among lenders now, including secondary holders, if you want to talk about the rote drill or the playbook, from the company side and from the creditor side, it involves an intense analysis of the capital structure, finding out where value is and where value ends, and beginning to implement decisions based on that essential evaluation analysis. And Chapter 11 is evolving to be much less about rehabilitating the company in a traditional sense, solving operational problems, and more as a means to implementing that transaction, which is planned outside of bankruptcy, and in which the levers that you're talking about, access to capital, particularly in the Chapter 11, become very critical factors. I also think that there have been some independent influences on this that have accelerated this process. Obviously, the limitations on the exclusive period mean that cases have to move much more quickly through bankruptcy. That adds additional impetus to having everything solved outside. I think you're right, too, that there are increasing circumstances where some constituencies are having to play catch-up. So often when you're doing this recapitalization analysis and you're seeing where value breaks off, you have a hard time convincing senior lenders that those constituencies have to be dealt with or thought about or whatever. And then you just play it out as the case evolves, whether they organize through a creditors committee or by other means and have to be dealt with.
Joe?
Yeah, Peter, I think the lens that I guess I want to look at it in terms of traditional, non-traditional, and whether or not you're going to go by the standard playbook, in part is really driven off of a liquidity outlook. And we spend a lot of our time at Conway McKenzie in the middle market, lower middle market, and liquidity is oftentimes not there. So as a part of the process and looking at kind of the best practices, you do want somebody to anchor the situation for you, whether or not it's out of court negotiating a deal with a buyer or otherwise the creditors, to kind of anchor it, and then you build around it what you need necessary to to effectuate the transaction. And so as we look at it and looking at the best practices, the deal's really got to hold together, either to attract the transaction and the capital or otherwise get it effectuated. And really, as in our efforts, making sure things hold together from the business plan, that the improvements that are necessary to further the business, and of course speed to try to get something done in these middle market deals. And when I look at it at speed, and everybody kind of has a different view on speed, but the fact of the matter is you really have to have not only your plan A, which is rolled out, but then your plan B, your plan C, and your plan D with regard to iterations on that. So as we look at traditional, non-traditional, anything is non-traditional in the middle or lower middle market space.
I'm going to turn to Bill Repko to wrap this discussion up in a moment. But first, I'd like to find my own view of what the playbook is, because Katie invited me to do that. My view of the playbook is an awful lot of professionals in big and middle market cases sort of process the case on an absolute priority basis, where there's a waterfall value. My colleagues and I at Gordian have a religious aversion to that. We believe that old equity has been marooned on the island at a certain point in time, and they used to have value, they may have value tomorrow. So, I'm all about throwing that playbook out and consistent with all fiduciary obligations, whatever they are, fighting for old equity to get value.
Peter, if I can just comment on this thing, I think back when Bill was writing his ones, they were a lot more liberal, and
That was just me.
yeah. And today they've the sources have decided that they can make more demands than ever before, and most of those are associated with timing. It's all timing related. Not necessarily the right thing to do, not necessarily the right timing, but if they don't set a time frame, they're afraid of running amok. And there have been numerous examples of running amok over a long period of time. And I'm the first guy to say you got to stop this train, but in some cases it wouldn't get done without it. Bill?
First of all, Katie, there actually was a playbook in GM, and it was sort of along the lines of the old saw. How did you go bankrupt? Slowly and gradually, and then very suddenly. I think the way I interpreted the issue was really to revolve around situations, one of which we're involved in now, that are extraordinarily complicated. We have 5 banking syndicates, 3 in Europe, 2 in Asia, different collateral, different positions, a set of bondholders whose indentures not written in English, and at least 2 countries, and other parties who provide working capital. And we don't know what the outcome is going to be, but if we didn't have a very defined process, it would degenerate into absolute chaos. And so that's not to say that creativity and alternative plans A, B, C, and D go out the window. But if you don't stay on the stepping stones, you're liable to get deep into the fire.
I think that's obviously true. I just wanted to add one more thing to what Peter said. It's going back to something that Steve said, which is that old equity often, and I think the distinction is that old equity often might have some value, but there needs to be time to let that value develop, and that's what Chapter 11 debtors don't have anymore. Not only do they not have it because of the financing strictures that I talked about, but also Steve mentioned limitation on exclusivity to 18 months no matter what. And then in the retail cases, or anybody that has a lot of leases, you also have to look at the 270-day absolute maximum without the consent of the landlord for extending leases. No longer can you go through an entire cycle and see what happens and see if that value develops. And so now we're having lenders and creditors come in on day one of the case and say, okay, the value is blah, and it ain't very high, and you're never going to be able to get more than that. And the arguments, even if you could get the judge to believe you, the arguments of yes, but we're doing this, 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 and this, and that value is going to increase, and there'll be more value not only obviously for creditors who get it first, but maybe for old equity. There's just not time for that to develop anymore.
If it was easy, then the smart people would be doing it. It's not easy. There's a lot of magic and creativity required, and
But on the playbook point, I think to kind of reduce it to something very simple and kind of anecdotal, and that is that when cases used to file, you would look at the newly filed case and you would be trying to figure out where the opportunity was for you in that case. Was there a way for you to get into the case? Should you go pitch the creditors committee? What should you do? Now, when you hear about a filing, you're reading, in most cases, about a story that has already happened.
Yes.
And you're reading about the players who are already involved and have already executed the transaction. I think that's a significant evolution.
Yeah, but I think that's a good thing, because one of our axioms is that companies that go into Chapter 11 to find a solution don't do nearly as well as companies that go in to implement a solution. So I think that's actually that's a good thing for the client. It may not be that great for the professionals.
Yeah.
Well,
No, you're right, Peter. I mean, the bankruptcy process in part is just the means to the ends, and the heavy lifting and being able to structure that deal outside to efficiently run it through. I mean, that's really, I think, where the professionals, making a lot of hay on the front end, and being able to, efficiently do it, which is, I think, very important for the business. And again, if you look at a middle market business or a lower middle market business, you don't have the luxury and time as a big corporation to be able to convince customers that you're going to get out on the other end, or be able to convince your suppliers to continue to work with you in that process. And so a story and a solution going in is really paramount to having a successful transaction.
I have to say that I think your comments about old equity are, way beyond the dark side. I think they're way beyond that, because I don't know how you restructure a company without gaining some sort of leverage with your creditors or your union or whatever. And I don't know how you can justify gaining leverage on behalf of somebody that's way down the absolute priority.
Come over and visit us one day, Larry, and I'll give you a tutorial on how.
Okay.
Because we do it in pretty much every case. All right, the next topic we're going to talk about is the art and science of consortium. Now, is that men and women, or is that bidding? No, okay.
I knew he was going to use that joke.
There's there's an increasing use of consortium, which I'm going to ask Steve to define.
Sure.
And group bids and 363 sales, Kodak and Nortel, two examples. How is this process best managed on the buy side? How is it best managed by the sell side and management? And is there a potential to either create a bidder where none would have existed, and or to create problems in respect to collusion? Is one person's consortium another person's collusion?
Right, and you could just say yes to all of those questions. Everyone who has been involved in doing 363 sales over the years knows that there are basically like two mantras that get repeated. One is the transaction has to maximize value, and if you've ever participated in a 363 auction on the bidder side, that you're beaten over the head with that as the auction goes into its third or fourth day of endless rounds and delays for bidders to see if they can come up with the money and the like. But it's all under the objective of maximizing value. But the other mantra that is repeated all the time is don't collude. We can't have collusion. Collusion is going to lead to a reduced purchase price. And that's very strictly enforced through the NDA at the level of the company, where they impose restrictions on your ability to talk to other bidders or to talk about your own transaction to anyone other than potential investors in your transaction. But it's also there in the bankruptcy code through Section 365N, and some very unhelpful case law which is intended to illuminate the entire problem growing out of the Trap Rock decision in the Second Circuit, which says you can't have an agreement that fixes the price or limits the price, but you can have there's nothing wrong with having an agreement that affects the price. So it's a very bright line that you can follow in practice.
I'm sorry, could you chart that sentence again?
Exactly. So clients are very uncertain about what this means when they're trying to formulate their bidding strategy, and you have to be very strict in telling them what to do and what not to do. But over the last 2 years, we have seen two very significant examples, admittedly in a specialized area, the sale of intellectual property, the sale of patents, where industry players who would ordinarily in a 363 context, because of issues of scale, because of the complexities of the underlying assets, which often involve, among them, the potential for cross-licensing arrangements where they've already committed to cross-license, and those things actually become depressors of value, where they have said, let's try and come together in some other fashion to bid for this asset. Let's form a group. Let's form an entity that the group will invest in, and the entity will acquire the assets. And instead of competing against each other, we'll bid together through that entity.
By the way, Steve, if I could interrupt, I think you've just laid out exactly why every one of these situations is collusion. But
I'm going to explain. I'm going to convince you that it's not. Nortel is a good example. In Nortel, you had two industry giants Google and Apple, who were going to be bidding against each other, and then you had a group of other companies, none of which had the scale to put together its own bid to compete with these industry giants. But in working in combination, they had the opportunity to take the assets away from those industry giants, and from the company's perspective, from Nortel's perspective, and the creditor's perspective, to increase the purchase price. So if the consortium was not allowed to form, you would have actually had a result where the sale would have probably gone at a lower price. And none of those individual members of the consortium alone had the ability to bid at the level of an Apple or a Google. And because of the cross-licensing arrangements that I indicated earlier, they were going to have problems even if they could compete in terms of their ability to
Steve,
exploit the asset.
When was the consortium formed in that case? Before or after the Stalking Horse?
Before.
Okay,
well
well,
before. Well before.
All right. Well, isn't that a problem?
You know,
Because, and I'll tell you why. I mean, I know there are lawyers out here, people who represent senior secured creditors or the poor unsecured creditors who want to see maximum value here. And now, before we've had any bidding, before we've had a Stalking Horse bid, now we have a group of bidders get together to consort.
You know, certainly in the Nortel situation, Nortel knew who was going to be coming to that auction, and Nortel was fully aware of the coalescence of the consortium and actually encouraged it, because they were going to have then there were actually four. There was Intel was an independent bidder as well. They were going to have a complement of four bidders, each with the economic power to potentially win the auction. As it turned out, as the auction was ongoing, the bidding got to the level that two consortium ended up being formed. Intel and Google combined with each other, and Apple and Rockstar combined with each other, and it took the bidding to 5 times the level that had been in the original Stalking Horse bid. So one would say, risks of collusion, you'd say question mark, what risk? You ended up with a tremendous auction result.
All right, my last question. That feels to me like a very results-oriented test of collusion. What if they banded together and they hadn't been able to do it? I'll leave that one hanging.
No, but I do want to talk about the other side very briefly, because we then had the alternative. We had a pool of assets in Kodak that people said was worth $2.6 billion. It ended up being sold for $500 million. You had two consortium in that case that had formed before the auction. The auction lasted on and off for 4 or 5 months, and perhaps with the benefit of the experience in Nortel, they decided not to bid each other up. I mean, there were some problems in the perception of the asset value too. Kodak had heavily licensed some of these underlying assets, and under the bankruptcy code, those licenses were going to stick. So there were depressors of value in there. But in the end, you had a result where the two consortium had to combine to get to the purchase price that was going to be acceptable to the creditors, because at that point they were saying, if we can't hit a certain level, hit a certain number, we'll just try to reorganize around the intellectual property ourselves and become, in effect, what's in the intellectual property world, a troll, going out there both offensively licensing but defensively suing people for infringement. So there one would say, well, it turned out 1/5 of the value. Maybe the consortium wasn't a good idea, but then the response is compared to what? How were those assets going to move? It was the only way in the end that they were going to move. I think that kind of overall, my observation would be debtors and constituents are becoming more flexible about this, and these rules aren't ironclad anymore, although one could argue that they never really were. We were talking beforehand about the experience with liquidators who used to combine all the time when they were liquidating companies. But I think we're going to see more of this.
I'm not sure there's a real difference in between consortiums and colluding. Anybody who ever did a retail liquidation, I've seen retail liquidations where there were 4 bidders and 3 of them included Al Cohen. That's just kind of the way it works. They've been doing it for years, and if you're going to get the best price, you need to either stop it and keep it under control, or you need to allow it to begin with.
All right, is there a difference between big cases and small or medium-sized cases in what we're talking about here?
Yeah.
Before you get there, let me add to what Larry said, because the retail dip loans that we were doing, they're obviously difficult loans. They're very big, and when you had your mystery shoppers go out and come back and tell you exactly what they would buy the merchandise for, it made for a very liquid and very successful fundraising occasion for retailers that otherwise were in huge trouble finding capital.
The input that I guess I would have on this is, on a smaller case or lower middle market, and we're involved with one right now where we do have intellectual property, and the question that we're going to wrestle with as the debtor is, at what point in time, as we're going through our process to solicit the prospective buyers, to try to start to match them up a little bit, because the intellectual property elements of it could cover off different elements of the business unit. Interested buyers are interested in a certain element of the business unit, but some of the IP was affiliated with another business unit. So we're going to have to, I think, make a decision about bringing the buyers together, really in the spirit of trying to generate the highest and best value.
Well, and the only thing I'd add is that, to Peter's question about is there a difference in the big cases versus the middle market cases, in a middle market case, sometimes you're thrilled if you have two bidders, and in that situation, obviously, if you're only two bidders, end up combining, and regardless of whether the price goes up or down, presumably it'll go down, I think you've got a problem. And but I think that what we're hearing here is that the stricture in 363 of the code is against a sale price controlled by an agreement among potential bidders at such sale. So it doesn't say the sale price had to be lower, it just says it had to be controlled by. And I think in all of these situations, I don't know if the agreement is determinative, and I know there's an art to negotiating these agreements and forming one of these consortiums where there are outs and each party is within a collared amount. But in a case where there are very few potential bidders at all, I think everybody really ought to be careful.
So the final comment on this topic, Steve, when I'm standing before the judge because I've decided to embrace the consortium idea, I'm going to ask you to represent me and explain to the judge how things are much more flexible these days.
Be happy to.
Organized labor. More and more cases seem to be involving organized labor. What are the implications for people trying to do deals? What are the best practices for dealing with unions and for advising management regarding unions? Katie, you want to kick this off?
Okay, well, I want to talk about, I was going to talk about just management and sort of sensitize everybody in this discussion, not so much to the problems with unions, but it's a similar issue problem with existing management. Now, sometimes, of course, existing management isn't popular with anybody, with any constituent, and should go. That's not what I'm talking about. I'm talking about the difficulties since BAP CPA of figuring out a way that you can keep existing management if you want to, because it's become incredibly difficult. You can't have a pre-petition agreement that you then think you're going to be able to assume, because some combination of your creditors and the U.S. trustee are not going to let you assume most agreements that are acceptable to management, even if they're not particularly rich. And then you've got the struggle post-petition of trying to convince people to stay and saying, well, if you're brutally honest with them as the debtor's counsel and say, well, nothing that you did prior to filing is going to stick, and we're going to have to come up with some plan that we're then going to have to go get approval from the U.S. trustee and the judge and the creditors. A lot of the first reaction that you get is, what am I still doing here talking to you? And it's also a very difficult ethical challenge, I think, particularly for the lawyers. I've come to the conclusion, and I'd be really interested to hear what Steve and the rest of the panel had to say about this, that what I should really do at the beginning of every engagement, whether we're going into Chapter 11 or not, is tell management that they should really get their own counsel. They don't each need their own lawyer, but I think they need their own counsel, because they're not my client, but I feel an ethical obligation to them. I know that they don't know, not generally speaking, not having been through this before, and I do. And it's not really ethical for me representing the company to say, well, you guys don't worry about it. Just stick around. We'll negotiate something once we file, and we'll get it taken care of, because I don't have any ability to assure that. I don't know, Steve, what do you think?
I agree with that, and I've been in situations where management has gotten their own counsel. I'd like to think in every situation it was because I recommended it, but I can't be that generous to myself. But they've been very astute about that, and we've seen in other contexts the problems of debtors' counsel getting caught up in the interests of people who are associated with the process, whether it's management or advisors, and there's been a lot of blowback on that.
Yeah, this is kind of like every other atrocity that's addressed by government. We swing from one side to the absolute extreme on the other side, and it is very tough to keep management.
I mean, the acronym for this is KERP, a Key Employee Retention Program. And with the 2005 amendments to the Bankruptcy Code, there was enormous focus on changing the standards that applied to the ability to retain management, to incentivize management to stay through a retention program. The alternative is the KEEP, which is the incentive program. Rather than paying them to stay, you pay them to achieve measurable objectives. And in the spirit of the reform, the cases now have been examining whether a KEEP is really a disguised KERP, and whether the KERP standard should apply. And in talking about this beforehand, I observed that the 2005 amendments were pretty rough on individual debtors. There was heavy impetus from the lending industry and what were portrayed as reforms introduced into individual bankruptcies, whether Chapter 7 or Chapter 13. I think many judges who deal with those cases every day say, well, the same thing was done in 2005 for management in a Chapter 11 case, and we're going to enforce those standards. And you're seeing the judges taking a very, very jaundiced look at some of these programs.
All right, I want to switch gears to which I thought was the topic, was organized labor and what the implications are for Dealmakers. Thank you, Katie and Steve.
Sorry about that.
I mentioned before, we only really represent boards and old equity. We've made two exceptions in the last year. We're representing the TWU, which is the largest union in America, and the Bakery Confection Union and Hostess. And we had huge success under the circumstances for the TWU in American by preaching what we preach to our boards of directors, which is you need options and optionality. And unions talk about following a playbook, a rote playbook, and instead imbuing them with some creativity and some options. We've been, knock on wood, really successful so far. And there, we encourage the union to negotiate with American on a new deal, not let it go to the judge to decide on an 1113 hearing if their contract should be thrown out, and simultaneously negotiate with potential acquirers, including U.S. Air, try and play them off against each other, try to create a spirit of competition, try and elevate their status in the case maybe beyond where it by all rights should have been. And that's worked out really well for them. That was a brave new world for our client, and I think it's worked out really well. So, Joe?
Yeah. No, Peter, that's some great insight in there. From our point of view, as we do, the restructuring and or potential transaction, the union is a constituent. They're in. You got on the front end. You got to have discussions with them, or otherwise support, or you're going to have it on the back end, necessary to get something done. And I think from a best practices standpoint, what I see that has been successful is really, one, you have to recognize them, of course, and get them into the process. But I think the second issue where I've seen success on, in terms of looking at their collective bargaining agreement, to the extent it's not workable, it's not workable, and deal can't get formed around that. But then you kind of peel back and say, what are really the essentials? And you know, you got the price of labor and you got the volume of labor. And I think on the price of labor, I think you're not going to get much headway. But in terms of the volume of labor, in terms of amending work rules and getting the union to agree to being on the post-transaction as flexible as possible with the production assets that you have, I think there's some headway. You know, there's some real headway on that one. And, you know, at the end of the day, I think, you know, maybe to Peter's point, that the unions, I think, are becoming somewhat more pragmatic with a focus in on maintaining jobs. Whether or not you're able to kind of push retirees and their benefits off the table, you know, potentially. But I think the critical element is really kind of knowing what ultimately is their hot issues. And I think clearly going in price and trying to modify price is a significant no-go.
Larry?
Yeah, I think that, you know, if I had been part of the previous panel where they asked them, what do you see as opportunities for 2013, 2014, and beyond, I would have said go to some sort of directory and find out every company that uses organized labor, because management cannot live with a cost that they can't control.
Yeah, but you know, I think it's time for a new paradigm in labor management relations. You know, the existing playbook historically, like what American Airlines did, you know, pay themselves hundreds of billions of dollars before filing and then blame labor for everything, has got to go. And labor has to be realistic about needing to be more of a partner and not simply, well, you told us you were going to give us this, and now even though you can't afford it, we still demand this. I think there's a need and room for a new paradigm in how they relate to each other, but that's probably for another conference. So,
yeah. All right.
Thank you to the panelists.